A woman is convicted of murder, and it is done with the admission of evidence that is arguably irrelevant, but the evidence against her is overwhelming. Should the Supreme Court overturn that conviction? Let's find out. Hey there, Tony DeWitt here. I'm a retired Missouri attorney now living my best life on a beach in Florida. But I do not dispense legal advice by video. With that understanding out of the way, here's what we're discussing today. This is Brenda Evers Andrews versus Tamika White, the warden of the Oklahoma State Penitentiary for women, I guess. And it's an interesting story and one that perhaps has more than one side. It would appear that there are a lot of things in this case that are glossed over in this part of the opinion. Now, it says it's per curiam, but that's not really correct. Usually per curiam means everybody agrees. In this case, there is a dissent by Judges Thomas and Gorsuch. So let's get into the holding here. An Oklahoma jury convicted Andrew of murdering her husband, Rob, and sentenced her to death. The state spent significant time at trial introducing evidence about Andrew's extramarital adventures and her failings as a mother and wife, and much of it later conceded was irrelevant. In a federal habeas petition, Andrew argued that the evidence had been so prejudicial as to violate due process. The 10th Circuit Court of Appeals rejected that claim because it thought no holding of the Supreme Court established a general rule that the erroneous admission of prejudicial evidence could violate due process, and the Supreme Court says that was wrong. By the time of Andrew's trial, this court had made clear when evidence is introduced that is so unduly prejudicial that it renders the trial fundamentally unfair, the Due Process Clause of the 14th Amendment provides a mechanism for relief. Now, that was Payne versus Tennessee. And here is the paragraph from that opinion that introduces that principle. They're talking now about victim impact statements. Such evidence is not generally offered to encourage comparative judgments of this kind, but is designed to show, instead, each victim's uniqueness as an individual human being. In the event that victim impact evidence is introduced that is so unduly prejudicial that it renders the trial fundamentally unfair, the 14th Amendment's Due Process Clause provides a mechanism for relief. As you can see, it's not spelled out very clearly that this would apply in other ways. It thus appears that this provision here is dicta and not a part of the holding of the case. But that's not what the Supreme Court decides. That case appears not to be directly on point, but let's take a look at what the Supreme Court says about it. First, on November 20th, 2001, Rob Andrew was fatally shot in his garage. As the dissent later tells us, he was shot with a shotgun, and he was shot several times. He died at the scene. Brenda Andrew, however, was herself shot, but instead of being shot with a shotgun, she was shot with a .22 pistol in the arm. Andrew further explained to the cops when they arrived that her husband was her husband, but they were separated pending divorce. She was now dating a guy by the name of James Pavat, but she and Rob had continued to see each other as they had 2 children together. Oh, those 2 children, they were upstairs playing a game on their TV with the sound turned up way, way loud. So they didn't hear the gunshots. Pavat and Andrew, instead of going to the funeral for Rob Andrew, traveled to Mexico together and soon became suspects in the murder. Eventually, Pavat confessed to committing the shooting with a friend. Pavat denied that Andrew had been involved. The state thereafter charged both Pavat and Andrew with capital murder, and the jury convicted Pavat and sentenced him to death. At Andrew's trial, the prosecution sought to prove that Andrew had conspired with Pavat, an insurance agent, to murder her husband for the proceeds of his life insurance policy. Among other things, the prosecutor elicited testimony about Andrew's prior efforts at reproductive therapy, I guess you would say, reaching back 2 decades, and about the outfits she wore to dinner, grocery runs, about the underwear that she packed for vacation, and about how she had a lot of fun in her car. At least two of the prosecution's guilt phase witnesses took the stand exclusively to testify about provocative clothing. Provocative clothing didn't cause the murder, and that really was completely irrelevant. It's what should have been referred to as bad person evidence, and it should have been immediately kept out of the case. And here's the Oklahoma rule on that. Although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading the jury, undue delay, needless presentation of cumulative evidence, or unfair and harmful surprise. However, in a prosecution for any criminal homicide, an appropriate photograph of the victim while still alive shall be admissible evidence when offered by the DA to show the general appearance and condition of the victim while alive. This says you keep out even relevant evidence if you have this problem, that it will be unfairly prejudicial. But there's no excuse for admitting it when it's clearly irrelevant, and clearly her clothing choices were clearly irrelevant. That's a mistake, but in terms of appellate review, erroneously admitted evidence is not necessarily sufficient to reverse the cause. You have to have prejudice that erupts from that. And in this case, the Oklahoma Court of Appeals didn't think that was the case. So during the closing argument, the state did something that I think is really kind of unusual. They demonstrated to the jury a certain piece of underwear that was worn by Ms. Andrew, and how she had multiple extramarital affairs. And they asserted at the same time that the victim, Rob Andrew, was himself a committed Christian and a really good guy and didn't deserve to be murdered. So it's okay to humanize the defendant, or humanize rather the victim in a case like this, but you really shouldn't use religious themes to demonize the other side. And I think that's what they were getting at. And the notes here says the dissent recites what it insists was substantial evidence of Andrew's guilt, contending in the process that this court inaccurately portrays that evidence. And indeed, it would appear that the Supreme Court does, in fact, portray that certainly in a more favorable light than it might deserve. In doing so, it prejudges the analysis of the prejudice by characterizing as fact the state's narrative at trial, and it says that narrative was hotly contested at trial. But it isn't the narrative that matters so much as the evidence, and I do think that the majority here gives it a little bit of a short shrift. But here's what I have to say about that, and that is, just like in baseball, they say the tie goes to the runner. You'll never find that in the rule book, by the way. That the tie goes to the runner, but close calls. When you do start having evidence pile up that is clearly irrelevant, only meant to demonize the defendant, I think you have to make a little bit of an allowance for that. And I don't think either the district court or the Court of Appeals here actually did that. But let's move on. The jury convicted Andrew and sentenced her to death. On appeal, she argues that the introduction of the irrelevant evidence, including evidence that she had these affairs, she says that unduly prejudiced her case. The Oklahoma Court of Criminal Appeals held that the admission of the evidence about the affairs hadn't been proper because it showed that her co-defendant was just the last in a long line of men that she seduced. So, they affirmed her conviction. And again, the note down here says the dissent asserts that the Oklahoma Court of Criminal Appeals held evidence of Andrew's close personal relationship with her two affair partners to be relevant because it gave credence to testimony that Andrew had shared with both of these men her hatred for Rob Andrew and her wish that he was dead. And indeed, that's what they testified to. Andrew never objected to the evidence that she had a close personal relationship with these men. All right, if you didn't object, then you don't get to, assert that as a basis for, overturning this conviction. So Judge Johnson dissented on the Court of Appeals, dissented in part. He said, in his view, the egregious pattern of introducing evidence that had no purpose other than to hammer home that Brenda Andrew is a bad wife and a bad mother and a bad woman trivialized the value of her life in the minds of the jurors. Therefore, he would have vacated her sentence. Judge Chappell dissented separately, indicating that he would have reversed the conviction. The court then notes that a divided 10th Circuit affirmed because it held that Andrew had failed to cite clearly established federal law governing her claim. The majority acknowledged that Andrew had cited Payne, in which this court said that the Due Process Clause provides a mechanism for relief when the introduction of unduly prejudicial evidence renders a trial fundamentally unfair. According to the majority, however, this had not been holding, it was a pronouncement. So it therefore concluded that Andrew had failed to identify clearly established federal law. This is kind of funny because these are the same judges that very often will find in the case of a 1983 violation that some principle of jurisprudence that we all believe is clearly well-settled federal law, that cops couldn't have known anything about it. So again, it's a little bit disingenuous at this point that anything can be labeled as clearly established federal law. I think that's kind of an oxymoron anyway. But there's this statute called the Effective Death Penalty Act, the Anti-Terrorism and Effective Death Penalty Act, and as a result, the majority declined to consider whether the Court of Appeals had unreasonably applied Payne because she didn't cite this supposed clearly established federal law. In dissent, Judge Bacharach condemned the state's focus from start to finish on Ms. Andrews' other activities, a move he argued portrayed her as a scarlet woman with loose morals. And then the court gets into the law. It says the court may grant habeas relief to a claim adjudicated on the merits only if the state court relied on an unreasonable determination of the facts or unreasonably applied clearly established federal law. An unreasonable application, in turn, is one in which there's no fair-minded jurist would agree with. So they go through some of the information and some of the stuff about Payne, and they say the legal principle that Andrew relies on, that due process can in certain cases protect against the introduction of unduly prejudicial evidence at a criminal trial, was therefore indispensable to the decision in Payne. That means it was the holding of the court for the purposes of the Anti-Terrorism and Effective Death Penalty Act. Importantly, Payne did not invent due process protections, it just held them to apply in that case. So, to make a long story short, to the extent that the Court of Appeals thought itself constrained by the AEDPA to limit Payne to its facts, it was mistaken. So they're essentially changing the law at this point in an opinion that's not issued as an opinion. The dissent maintains that a reasonable jurist could agree with the 10th Circuit understanding of our precedent. That assertion conflates the deference federal habeas courts must extend to a state court's application of this precedent with the court's duty to independently identify the relevant, clearly established federal law. I've read through this entire opinion. I don't think that is an accurate statement about the dissent. Because the 10th Circuit nonetheless held that no relevant, clearly established law existed, a ruling that the Court of Appeals reviews de novo, it never considered whether the state court's application of that law was reasonable. On remand, meaning that when this case gets kicked back to the 10th Circuit, the Court of Appeals should conduct that inquiry in the first instance. Specifically, the question now is whether a fair-minded jurist reviewing this record could disagree with Andrew that the trial court's mistaken admission of irrelevant evidence was so unduly prejudicial as to render her trial fundamentally unfair. So they phrased it in this stilted method in order to set the tone for the review. But realistically, the issue is, was the admission of this evidence, first of all, unduly prejudicial, and two, did it prejudice her case? Was it fundamentally unfair? The dissent makes the argument that it wasn't unfair because the evidence was so significant. The Court of Appeals must ask that question separately for guilt and sentencing phases. As to each phase, it might consider the relevance of the disputed evidence to the charges or sentencing factors, the degree of prejudice Andrews suffered from its introduction, and whether the trial court provided any mitigating instructions. Now, actually, those things are pretty good guidelines that the court should follow. The ultimate question is whether a fair-minded jurist could disagree that the evidence so infected the trial with unfairness as to render the resulting conviction a denial of due process. So they grant the petition for certiorari, and they vacate the judgment below and remand for further proceedings consistent with the opinion. So Justice Alito concurs only in the judgment. I concur because our case law establishes that defendants' due process rights can be violated when a properly admitted evidence at trial is overwhelmed by a flood of irrelevant and highly prejudicial evidence that renders the trial unfair. I express no view on whether that high standard is met here. Now, the dissent is about twice as long as the principal opinion, and it goes through the evidence in detail, and it makes a pretty compelling case that the Supreme Court is really wrong on this issue, but only two judges sign on. That's Thomas and Gorsuch. And so, in some respects, the dissent here is a little irrelevant because they're not reversing the conviction. They're merely vacating the decision of the habeas court and sending it back to the Court of Appeals at the 10th Circuit. So there's two issues here. The first is, was this trial fundamentally unfair? And I don't think that's a close call. I think they loaded this up with a lot of unfair, very prejudicial evidence, particularly in the middle of the Bible Belt where Oklahoma sits. I mean, that's the kind of stuff that's going to get a jury really upset at this young lady. And I think that it's totally appropriate to consider that highly prejudicial evidence and irrelevant evidence, and that's a violation of due process. You are entitled to be tried for the crime on which you were in trial, not whether or not you were not the most chaste person in the state of Oklahoma. That's an important distinction. The other issue that I see, which is in some respects more important, is the court sought to do justice without doing injustice to its body of law that it has created on the issue of habeas. In other words, by putting it out this way, where it's not a numbered opinion, an opinion that is set out there for precedential purposes, by doing that, letting it go when you let a bunch of orders go, it really tends to be the court wanting to have its cake and eat it too. They want to do the right thing for this woman, or what they consider to be the right thing for this woman, but they don't want to change the precedent. They don't want this case really being cited for the proposition that Payne has actually decided this issue. Obviously, Justice Alito thinks that it has. Thomas and Gorsuch don't. The rest of the court seems to think that it does. We'll have to watch the cases as they come down in the next couple of years to find out whether or not the court got this one right. The decision of the habeas court has been vacated, and now it looks like the 10th Circuit is going to have to redo its analysis and perhaps spend a little bit more time explaining why it reached the opinion that it did, if it wants to carry that opinion forward, or whether or not maybe we do need to issue a vacation of the actual underlying sentences. We'll just have to wait and see what the 10th Circuit does. I could go into that dissent a lot further. It's a really well-written dissent, but it would make this video way too long. So that's what I have for you today. Thank you so much for watching the video. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.